Got it. All right, so just calling to order this subcommittee of the Remedies Subcommittee. I would note it does look like we have a quorum with myself, Mr. Esme, and Ms. Evans. So perfect. Just before we get into plans and topics for today, I just want to note that the August 22nd meeting minutes have been posted. So if there are any corrections or edits or notations, please let me know. Hearing nothing, the minutes are approved. All right, so Gina, just kind of filling you in and kind of circling back. I know at one point there, I think the goal today, we were going to really start talking about both the expungement issue as well as the kind of just process itself. And Josh, like many of us, has just been completely swamped, which I fully appreciate. I don't think I saw straight all of last week, Josh. So my sympathies are 100% with you. And so I think just kind of we can sort of start talking, see how far we get today. And maybe even before we forget, the last big group meeting. Well, I'm just looking for your email here for a second. Sorry.
No worries, Madam Chair.
Yeah, we got to get moving.
Timeline. I'm just looking for the timeline email.
Correct me if I'm wrong, Ms. Evans, but the large group had sort of discussed the next Friday meeting, which would be September 23rd, coming up with a work plan for the rest of the year for the full group. And then the meeting after that, October 7th, as sort of an informal, well, a semi-formal deadline, as it were, for subcommittees to have their recommendations in.
And not like word for word, like super written out, but like bullet points so that folks that need to go back to the folks they represent to be able to say, like, here's what the subcommittee that I'm a part of is looking to get consensus on, so that we don't run into the glitchiness that other task forces like this have run into. But we're like, we need to like get to the end of our work here pretty quick.
Well, and I think our subcommittee as a whole, I feel like, our first block, we've already got our bullet points. I had put them into a PowerPoint presentation. Our preponderance of the evidence, I'm pretty sure, Will, at one point I sent you an email, I think, with kind of a summary of our bullet points. So really, I think our subcommittee, honestly, I think we're doing fine. I'm not worried about our subcommittee.
Yeah, we're moving along nicely.
Yeah. And so I think, even if we talk a little bit today about expungement and process and accountability, and then maybe next week, because I know we've really brainstormed on a lot of ideas, I think, over time, that I think those final ones for our group will probably come together pretty well.
And did we move to every week or every other week?
Well, that's the next thing. So today, Will reminded me it's our last scheduled meeting for the Remedies Subcommittee. And so I guess my proposal would just be, sorry, pulling up my calendar here. Even just looking, at least for me, weekly would be difficult for us to try to do a weekly meeting. I'll be 100% honest. But looking ahead, some sort of a bi-weekly, so like the 26th, that looks good.
26 is fine for me.
Yeah, the 10th is questionable. I'm technically scheduled for a jury trial, that cattle call.
So what about 2 weeks in a row then?
I have another jury trial the next week or the week before. So the 3rd and the 10th are just really difficult for me, but it's possible. I think it would make sense to put it on for the 10th, if that's all right with people. And then the way the jury trial cattle calls work is we get an assigned time, and we may not even be going down right at that time. I won't know till that like Thursday before where I fall in priority. So to me,
Just a quick question. Is the legislature working that day for our state staff? That's
Is
Indigenous
that-
Peoples Day / Columbus Day.
That's an excellent question, Mr. Esme. I
No.
believe so, but let me double check.
I don't think so. I think they have it off.
But then we'll have
Cause
to,
it used to be Columbus Day, right?
My
No.
calendar still says it's both. I don't know
Yeah.
what is the personally prefer Indigenous Peoples Day, but I don't know.
Amen. Yeah, I feel like it's a national holiday. No? No?
I don't
no,
know. I
the
think it's
courts are open.
courts are
Oh,
definitely
okay,
open.
then it's not.
Sorry, I might need a second to follow up on this.
Yeah,
No, I
courts-
feel like if courts are open, then it's not, right?
yeah, but it may still be, like, I know, that day, like, for example, like the city attorney's offices used to be closed. So like some government organizations do close that day.
Okay.
But I think it's more of an individual determination.
Looks like the federal government is closed.
Carol, do you know, do y'all have that day off?
I'm not sure. I'm checking right now.
Okay,
Keep talking and I'll get you guys the answer.
okay, awesome.
What, and if it does, work out to be that, the 17th, unless I'm still in my jury trial, that could work too. So,
Cause I want to make sure that we have at least a day that we give to accountability.
Yeah.
And I don't know what that looks like.
Well, so I was actually kind of thinking maybe we could start that today. I don't think we need all of today to talk about expungements.
Okay. And then process too. So we.
And
we
then
still have
and
a
then the
couple more
process
days
part,
left.
I want to punt till the next time because I didn't get my homework done on it.
Okay, perfect. And so how many days is that we're talking about though now? Like,
I think
If we-
one for process.
okay. So that, and then,
Because
And
I
then-
think even if we're like yeah, I think maybe two.
yeah,
and
so then we're talking about 3 more days of work, right?
Right.
So I'm a little concerned about,
what was the deadline again? I'm so sorry. You said it and I already forgot.
October 7th, Madam Chair. And
October 7th?
two task force meetings from now.
Oh, I thought I heard end of October. Okay.
Yeah.
Well, then I think we should plan on one day for process.
And it does look like staff will be working on the 10th.
Well, let's schedule for the 10th. So
so
my,
that's only, is that only 2 more meetings between now and? Or only, is that only 1 more meeting, this one and 1 more?
The 10th would be after the weekend following the 7th, yeah.
But if we can do expungements and accountability today, and then hopefully get to the end of process by the end of the 26th, and maybe if not, see if we can figure out a time to meet before the 7th.
Okay, all right. All right, awesome.
And in the interim, I can put the 26th and the 10th on the calendar, just so we have the flexibility.
that makes sense. Yeah. Okay, so let's start. Why don't we just start? Let's just start with expungements. Let's just
Okay,
get,
let me
get
do
that in.
let me do like a quick overview, just sort of for the record. I know both
Yep.
of you guys are somewhat familiar with the process already, but
Yeah.
we do have remote viewers. So what we're talking about is when somebody petitions the court for an expungement of the record of their case, and we have 2 relevant state statutes. One dealing with adult expungements and one dealing with juvenile expungements, both of which empower state court judges to grant orders that seal essentially government held records. So these can be the records that are held by the judicial branch, the court like Mincis records and all of the like party filings that become a part of the court record. All of that can get expunged, but the expungement, at least in many cases, in its sort of most effective form, also reaches to other parts of the government, like the police department and the city attorney's office and the Department of Corrections and probation, and sometimes to the Department of Human Services. And the statute does allow judges to direct an order that would compel the Department of Human Services to seal the record, sort of any record relating to a case that gets expunged. And when that happens, then, DHS, still sort of technically has the record, but they can't open it, they can't use it. And it becomes a remedy, sort of an alternative remedy that sort of sits next to set-asides, to get people to be able to pass DHS background checks. An expungement is nice, and is, in some ways it's a better remedy than a set-aside. And the reason I say that is that once you have an expungement, you can be certain that this is not coming up and you will not be disqualified on any future background checks, so long as, of course, that expungement has reached DHS. Whereas if you get a set-aside, you might not get a set-aside the next time you apply for a job if the sort of the contours of the next job are different than the one that you had previously gotten a set-aside for. The victims are more vulnerable, or I'm sorry, the vulnerable people are more vulnerable, or they're more similar in some way to the victim of the crime. Those could be sort of factors that are independent of an individual's rehabilitation that could, at least in theory, cause DHS to decline to set aside a subsequent background study after already granting one. Also, personnel at DHS changes, and the commissioner changes, and it's a political appointment, and priorities at DHS could theoretically change. So all of those things, I think, make an expungement an even better remedy than a set aside. There are pretty strict criteria to get an expungement, and the expungement statute, at least the adult one, describes an expungement as an extraordinary remedy. It is not supposed to be kind of like the default that like everybody gets an expungement eventually, at least not the way that the statute is currently composed. That's what extraordinary in that context means. It means it's not an ordinary remedy. And the burden, at least in a case that has resulted in a conviction, is on the person seeking the expungement to prove by clear and convincing evidence that the benefit that they would get from the expungement outweighs the cost to society and the community of taking this information away from the public and taking that information away from agencies like DHS. And typically people are doing that by showing both how the record has caused them problems, so that the judge hearing the expungement petition has a sense of what is at stake and what the benefit for the individual will be if they get the expungement. And then also hearing evidence about how the person has changed. The statute uses the word rehabilitated. In a sense, the way I describe it when I'm advising someone on an expungement is they need to be able to convince the judge that they're no more likely than somebody who doesn't have this record to have something like this happen or do something like this again in the future. So they've, whatever it was that put them in the position where they got convicted of a crime, they have changed that. That's no longer part of their life. They've learned their lesson. They've solved the contributing issues, and the judge can be confident that they, essentially that no one will get burned if the judge grants the expungement. And so, in addition to that, there are statutorily mandated waiting periods for people based on the severity of the crime that they're convicted for. So if someone is trying to get an expungement for a misdemeanor, they need to have completed their sentence and then had a clean record after that for another 2 years following discharge of their sentence. And any new intervening conviction is going to reset that timeline, and they're going to need to get to the end of that sentence and then have 2 years clean after the end of that sentence before they could get either of the now multiple crimes expunged. So it's 2 years for misdemeanors. It is 4 years for gross misdemeanor convictions. And then there's a small subset of felonies. It's not very big. It's basically the bottom 2 rungs of the sentencing guidelines grid, minus a few offenses that, even though they were already at the bottom of the sentencing guidelines grid, the legislature didn't feel comfortable allowing to have expunged. But that small subset of felonies that can be expunged, you need to have completed your sentence and then been off paper and had a clean record for 5 years before you're eligible. It takes a while to get an expungement, and it's not easy to get an expungement. But when you do get it, it is a good remedy. Now, the issue that we need to discuss is, how do we want DHS's statutes to be oriented to the expungement statute? Right now, they're essentially treated the same as any other agency that has copies of the records, like the BCA or the sheriff. Anybody who gets a copy, for whom the person seeking the expungement would like to have that agency's record expunged, they have to be given notice of the hearing, and they have an opportunity to object. And that objection can be, independent and different from the objections coming from other agencies or coming from the prosecutor. And DHS is a little bit different than most of the other agencies. Most of the other agencies are essentially law enforcement agencies that have records and keep records for, the purpose of having a record of what they did, or, because they need a record to supervise the person on probation or oversee their sentence in the Department of Corrections or whatever it is. DHS is really the only one who has sort of work to do with the record and exercising discretion about whether to allow somebody to work. That's not something that any of the other agencies that are typically involved in expungements, really do. Maybe that some instances here and there, but for the most part that orients DHS a little bit differently. And so when they get, what we learned at a previous meeting from them is that this was the presentation last year, was that when they get noticed with an expungement, they take a look at the record and essentially they decide, is this somebody who we would likely grant a set aside to? And if they would likely grant a set aside to them, DHS told us that they then don't object. But then if it's a case where they maybe would want or wouldn't grant a set aside or would want a disqualification to still be in place, then they do object. And I think altogether they told us that in the last year they had only objected to like 2% of expungement petitions, which is really small. I don't think that has always been the case. My sort of anecdotal experience practicing is that early on, because the expungement statute as it currently exists was reformed in 2014, and for the first few years, maybe 5-6 years after that, it felt like DHS was objecting like pretty much always, and were making arguments that suggested that they just saw like they were trying to sort of head off having their records expunged altogether, regardless of how they intended to exercise their discretion vis-a-vis the person submitting a background study. So it was, they were making arguments that were process arguments, like, the expungement hearing isn't a sufficient enough hearing to create the type of record that should supplant the work that DHS does. And so, Judge, you should not expunge DHS's records. You should just let us do our job. And maybe we'll grant a set aside, maybe we won't, but that's our territory sort of, and the judge shouldn't intercede in that. So clearly that's not the way the current commissioner is looking at it and the current department is looking at it. But again, a concern is that things can change at DHS and they could go back to objecting a whole heck of a lot more than they are on sort of those sort of more process grounds. So that's sort of I think the big policy question is, do we want to have the legislature direct to DHS how they should sort of interact with this expungement process? There is one other small technical fix that I think is going to be easy for us to agree on, which comes into play in adult expungements. There's a provision that allows for an expungement to happen without a full petition process. If the prosecutor agrees to it, and that conflicts with language in DHS's statute that says that notwithstanding an expungement, they can still have access to an expunged record unless they were given notice of the petition. And so the presence of the word petition in DHS's portion of the statute sort of seems to preclude the use of this sort of streamlined expungement process that the legislature created in the adult statute. My understanding is that DHS actually sort of already has a workaround in that and is letting it go. But I think it would be best if, for the statutes to not have that conflicting language. And my recommendation on that is just that we come up with language to make it clear that as long as DHS gets notice of the expungement request, it doesn't have to actually be a full petition if it's coming under this other provision. That as long as they get notice and the opportunity to object, that they'd still be bound by the expungement. So that would be my recommendation for the technical fix. Like I said, I think that's an easy lift. I think the bigger question for us to think through is, do we want the legislature to prescribe how DHS thinks about when they object to expungements or not? The sort of options that I see on the table, one of them I think is to just plainly say, no, we don't want, if a judge grants an expungement, that's good enough. And DHS can just take have the legislature say DHS should just take a hands-off approach on the expungement, and not try to make their own case. I don't know, how popular that would be. I wonder if DHS might. Well, I guess I don't really know what their position would be. On the one hand, that would make their life easier. That would take work off their plate. And I think it is justifiable in that, the expungement itself is already an extraordinary remedy. You've got a judge who's qualified to make determinations about whether someone's rehabilitated or not. I think arguably, a lot of times the judges are actually in a better position. Sometimes these judges are giving expungements on cases where they've worked with these clients for a long time. That's not always how it is, but it is often that way. The third option that's maybe a middle ground, and I'm open to other ideas too, is maybe to codify that what we want DHS to look at is, basically take the expungement petition as a de facto set aside and do the analysis based on the information in the expungement petition if you would grant a set aside, and if you would, then don't object. Which is sort of codifying what they're doing right now.
Say that one more time, Josh. Just that last part.
Yeah, basically another option would be to essentially try to codify what DHS has told us that they're already doing, which is making the decision about whether to object to an expungement by essentially analyzing it in the framework of, would we set this aside if this was a set aside request and not an expungement request? And if they answer that question, yes, according to the presentation they gave us before, then they decline to object.
So my question is, though, if the decision that gets made and the legislature agrees with it is to get rid of POE, isn't this kind of that along those same lines, that they're looking back at something that's already been kind of decided on?
I think so. And that's why, the other option I think we have, and maybe the one where like my heart would go, is to have DHS not weigh in on the expungement at all. And if it's granted, then it's granted, and that should basically what we would say, how we would frame it is that DHS should take no position on the expungement, and if the expungement is granted, it's essentially a de facto
set aside.
Well, it's not even a set aside; it's better than a set aside, right?
Yeah.
But
well, it's supposed to be sealed, and so it just is sealed from them also.
Right, and we could even say any expungement, regardless of whether, I mean, one of the nice things then would be the expungement petitioner wouldn't even have to monkey with DHS. We could just frame it as any expungement would serve to clear them and give them the ability to pass a DHS background study.
Mhm. Why isn't it sealed from them also?
Well, the way that it works right now is any agency for whom you want their record to be sealed, you need to serve them a copy of the expungement, and they have an opportunity to object, and their record is only sealed if the judge
yeah.
includes them in the order.
Got it.
And so if you
Yep,
don't
said that.
copy DHS at all, there's just no order that ever goes to them. Their record is never sealed.
Yeah.
And then on top of that, the statute gives them particular access to even sealed records. So like if you did copy the BCA, but you didn't copy DHS, and you get the BCA's records sealed, and then 5 years later you go and petition, DHS will tell the BCA, we're not part of the expungement order. They'll point to the language in the statute that actually requires the BCA to give them the sealed record.
So it's for ones that aren't done properly.
So a
Right.
couple,
It's a trap for people who don't know what they're doing, you know. I mean, it's not designed to be a trap, but it functions that way.
right. So a couple, I guess, kind of thoughts. To me, the expungement without the petition, I think to me, that's a simple technical fix to the statute of just sort of, we're fixing the language so that it includes some sort of notice, like you said. Like, to me, I think that's just a technical fix. So as far as then the expungements, I just want to make sure I'm understanding. So is your thought process that the expungement statute or the DHS statutes would specifically say that they don't get to take a position on an expungement regarding their own records? Because I see a lot of pushback on that. And then I also, and this is just me sort of speaking generally, I guess I'm a little concerned about specific language as to what DHS should look at. Because, for example, like in the case of juveniles, where the juvenile expungement statute is much different. And like in my case, where I was able to get a permanent DQ offense expunged, DHS never objected. And I'm worried, normally that would have been a lifetime DQ. And if now we're saying some sort of a standard that if they would have granted a set aside, we could end up affecting, let's say, a bunch of juveniles who maybe could get a DQ, a permanent DQ expunged because it's in the public interest.
Yeah. So
I just want to be
part of
cautious.
it is we got these moving parts here, right? Because another part of our recommendation is to get rid of the bars to set asides altogether. The permanent bar.
Yeah, but what if that doesn't fly?
Yeah.
Right.
Like we can't assume stuff's gonna go and make decisions based on that.
Well, and then I guess I would see a lot of pushback of, like, for example, and this just an example that comes to mind is like DWIs, trying to get them expunged, for example. You could have a DWI with a child in the car. So you're going to not only the Department of Public Safety, that's also going to DHS, because that's considered to be, there's going to be a DHS record because of child protection would have been involved at some point based on those types of allegations. And the Department of Public Safety, especially on DWIs, objects. They don't want those expunged because they've got the 10-year look back window. And I see a lot of pushback of DHS can't analyze based on their own records, but we can't tell the Department of Public Safety. They're going to be objecting. I guess I just see, and then I also just wonder, based on some separation of powers of the legislature trying to tell DHS how to view their own records when we've got all three branches involved. I guess I'm just, in my head, I'm just trying to kind of think all of it through.
Yeah.
And is there really a good, and I'm just sort of speaking as I'm trying to think through all of it. of the potential pitfalls. I see what you're saying though, like if they would grant a set aside, why go through all of the work? Like 100%, I get that.
Well,
I'm
on
just
that part,
thinking
honestly,
through
I'm more interested in solidifying what the agency is doing now and protecting it against, putting it in statute and protecting it against a different regime coming in and wanting to take a different position.
Right. But I think that's where we also have to rely on the judicial branch to do their own analysis of, under the expungement statutory framework. And that's just my only,
Yeah.
because the last thing I would want to affect is, me speaking, on behalf of that former client of mine, that was his only remedy. And he would have never gotten a set aside. He was a permanent DQ. I don't want to impact the people like him.
Yep, unintended consequences.
Mhm.
For sure.
So are you guys kind of leaning towards just doing the technical fix and then that's it?
To me, I wonder if it's more of, maybe I just, in my head, I'm trying to think of what that statutory language could be.
Or do we flag it? Do we just flag the issue and say, here's an issue that came up that that needs its own like standalone, or like, I feel like in it's 25 minutes. We have 25 minutes left of our meeting. Are we going to solve this today, Josh? With, like it's a whole, like we could talk about the technical, that it needs a technical fix. Like, here's the issue. This needs a technical fix. Like, and to talk to DHS, even to bring it up at one of the bigger meetings, we could flag it for that and talk to Kulani about it and just be like, here's the issue that we're seeing. Here's, if we were going to, what would be the fix, do you think? Is it an easy fix? Is it something that we could recommend here? What would that look like? Because what does it look like? Without impacting a bunch of other folks, just that they not take a position on them.
Well, I also wonder if, and if Josh, if you ever have time, I think it would be great for you to come to the disqualification subcommittee meeting, because there has been a lot of talk there. And I think about, like, for example, let's just say if there's talk about reducing the amount of crimes that even are
Yeah. I get that.
Then that's fewer expungements that might be objected to also.
Right. And shortening the time period too.
Yeah. Well, because that's one of the comments that I've made in that subcommittee about why would we have a 5-year DQ period on a misdemeanor where somebody can expunge before their DQ period is even potentially up.
Yep.
Like, that's just nonsensical to me. But I think that's a.
Yep. So, and I agree, but I also think that, like, to only have a 5-year disqualification for 2nd-degree drug possession, and then to have somebody who's got 15 theft charges of between 500 and 1,000, that's not even off probation yet, to not have any, like they're working with my grandma in the nursing home and access to her wallet. Like, I feel like we got to have some, like, I don't know that we're there yet either, Lucas. I'm not all the way there yet.
No, but I think, and I'm not saying that we are, I'm just saying, like,
but that's where we're at in DQ right now.
Yeah,
that's where we're at in DQ. It's either 5 years for the bigger stuff or nothing. And that, like, I'm not there with you. And so for sure, other folks aren't that are right. No. And so what's the other thing? We need to present another thing that's like when folks are off probation, and then the fact that we're not even talking about from when yet. like
Yeah,
when
the
people are,
DQ subcommittee is definitely, but I think even, but back to the expungement, I mean, I think there is some consensus in the DQ subcommittee on certain crimes would no longer be there. They might
oh,
be
yeah, for
different
sure.
time frames.
Yeah.
Which to me then that would reduce even just from the expungement standpoint.
Mhm. Yep. Well, yeah,
Well-
it's ridiculous. You can get it expunged faster than it falls off. Like there's a ton of that.
Yeah, I mean, that's almost always for each of the misdemeanor, gross misdemeanor, felony, the waiting period for the expungement is much shorter in all three of them than the current DHS.
Yeah, if it's
Oh.
expungible for felonies.
Mhm.
If it's expungible.
Right. Well, I'm okay with the idea of kind of going back to DHS with our hands open a little bit and saying, look, we actually kind of really like the way that you told us that you're exercising discretion right now. You know, what we'd be interested in are ways, you know, to lock that in.
And lock that in at the application point, because are they doing that during the set aside process or at the application process?
No, they'd be doing that when they were deciding, so they get notice of the expungement. And we're gonna fix it so it's either notice of the petition or notice of the prosecutor agreement
Okay,
expungement. But either way, once they get notice of that happening, they have an internal agency decision to make about whether they're going to object to that or not, and
Okay.
enter into the case and, you know, file an argument and go to court and argue against the expungement. And from what they told us in the previous meeting, the way that they typically decide that is like, I think they framed it, would we give this person a set aside? But Lucas, I wonder if the question is actually, if we had the power to give this person a set aside, would we? Because like you said, they did not object to a juvenile that would have been a permanent disqualification that they could not have given a set aside to, but they still, I'm sure, looked at it and thought, you know, we think this person can work. And so to me, that seems like if unless we wanted to go so far as to just tell DHS to keep their noses out of expungement, which I get we don't want to do. That seems like how they're doing it right now is pretty close to what I'd want them to be doing. And like I said, that's a pretty big change from what it was not that long ago.
Well,
You know,
and I like how you phrased the question, just if they had the power to give the set aside, would we? And that's their analysis.
yeah.
and so what I'm hearing you say, Josh, is that we just want to get that locked in to protect how they're doing it now against any changes in the landscape.
Yeah, and you know, maybe I'm paranoid and jumping at shadows, but you know,
I hear
I
that.
feel like anything criminal law related like can change and can go backwards in ways that like recreates harsh penalties that we're already, you know, we're deciding here in this moment we don't need to have. So
Well, I love that bullet point. DHS, we appreciate what you're doing right now, and we would like to get that locked in.
yeah.
I think that in all that we've done and said and all that's going on, I love that bullet point.
Okay.
So,
Yeah.
One other thought, and I don't know if this is feasible or not, but it's kind of brainstorming a little bit. We may end up with a category of permanent disqualifications that we think DHS can't set aside without losing Adam Walsh Act money, right? I wonder if an expungement of the DHS record of that case could allow the person to pass the background check without interfering with Adam Walsh.
Most of those Adam Walsh crimes and conduct though are not expungible.
Right. But something that we could add is that a judge could expunge just DHS's record of those types of cases, not expunge the public record.
I feel like that's outside of our scope, Josh.
Okay. Fair enough.
And especially September 12th.
Fair enough.
To be,
Yeah, well, and I also just think, I mean, to me, I don't know how much good that would do. I don't know that the federal government would really approve kind of that. I feel like they'd be like, nah, nice
workaround.
try.
yeah,
A for effort,
yeah, good, nice workaround, but no.
but no. Yeah, I wonder how they would. Well, and I think, I mean, keep in mind, one of our very early recommendations was that Adam Walsh, that those crimes are disqualified only when Adam Walsh is actually necessary, that
Right.
we actually have those different buckets.
Yeah.
And so I think,
No, I get that. I was just trying to,
Yeah.
it's sticking with me that we can't do better for those people.
Yep.
So I'm just looking for ways
Yeah.
ways to do better for those people.
well,
But
and I think the hard part is just from a public safety standpoint, you'll still get the pushback because the Adam Walsh really are the serious of the serious.
Yep.
But so I think that people that it will still benefit, and where the expungement statute can still protect them are the juveniles.
Yeah.
Because the Adam Walsh doesn't cover juveniles, and the juvenile expungement statute is just more broad.
yep. Okay.
We can really look at brain development and that somebody is a contributing member to society, and really what are the safety risks.
The other thing too, the 23rd, is she coming? Did you send her an invite, Corey from Harvard?
Yes, Ms. Evans.
So Corey from Harvard, she's a doctor, Corey Vincent, from Harvard, is coming to talk about once somebody's been sober and like crime-free for 5 years, that the chances of them relapsing and stuff drops down to the same as like the general public. And she has like this whole public health thing she does with it, and she's fabulous. So she's going to come present on the 23rd to the whole task force and kind of talk about that like 5-year the measure and the meaning of that 5-year mark. And I think that'll be a good way for us to like go into the writing and really kind of the negotiation of what we're going to have in there. And I wanted to have that kind of be the last presentation that we have around that 5-year stuff. And then she also talks about the impacts of Black and brown populations, why it's different and all that. So I hope that will be helpful for the group.
So no, I think that's great. And I think that'll be helpful. And I think that'll be helpful also for the disqualification subcommittee as well. So I just kind of want to circle back to make sure I try to do, our bullet points of our recommendations. I think if we're all kind of on the same page and we can all agree, as far as expungements, we'd recommend a technical fix to the statute to bring that non-petition portion in line, that it would just say that either notice of the petition or notice of the prosecutor agreement, that would essentially start the clock for DHS to respond. And then also just kind of an open, kind of that, just more language, or, sort of a open question to DHS that we do appreciate their analysis. And is there any way to solidify their current view of expungements, such as if they had the power to give the person a set aside, would they? And is there any way to solidify that analysis to protect against changes in the landscape?
Perfect.
Okay. So I think if we're all good with that, I think that I think gives us some bullet points and gives us some good solid, I think, recommendations to DHS, along with, I think it's important to still acknowledge the work that they are doing and I think this shift and how they're, we can acknowledge and appreciate some of what they are doing. Yeah. Okay. Anything else with expungements? Anything else people can think of right now?
I have something else to talk to you about, Josh, but let's do it after this meeting.
Okay.
In regard to that.
So then I think let's move on to accountability. And I know, Tashonda is not here right now, but I know this has been a very important one for her, and I guess definitely, wanting to be respectful. I'm also trying to figure out how we do that because there's immunity and other things like that. And I don't know if other people have kind of some thoughts as to, I think that one is going to be more of kind of a bullet point recommendation, but kind of just some sort of aspirational, whether it's making sure that there's, for example, there's oversight, if it's an attorney oversight, whether the legal department actually takes a look at more, I'm not quite sure. And I think there's a difference between DHS and, for example, like child protection, who's technically a county agency.
Mm-hmm. Yep. And do we highlight the disparities, right? Because we had some pretty remarkable disparities for Black and brown bodies.
Yep.
And then talk about, potentially, some potential proposed options for a community oversight board, legal oversight board. Like, we can give them some here, here's what we think might be helpful to just have some eyes on that. Or like, yep, I don't know. I would love to hear what Tashonda is thinking.
I also think there were some, I definitely the Black, like we were saying, the Black and brown bodies, but I think if I remember correctly, there were also some disparities based on race. Not race, gender.
Yes. I feel like that has to do though with a lot of what we're talking about is like helping careers. And that just tends to be more women than men to begin with. So I don't know that we can, I don't know that we have the data to read into that as much. So.
No, and I think that does make sense.
So can I throw out an idea?
Yeah.
Just so, I think it's going to be really hard to create any kind of civil cause of action that allows you to go after DHS for damages because of qualified immunity. But one thing that we could look at doing is maybe borrowing language from the way that the sheriff's offices do conceal and carry permits, which is kind of a similar analysis if you think about it, right? You're asking a government agency to do essentially a like risk of harm background check and then hand out a privilege, conceal and carry versus being able to work in an industry based on passing that like risk of harm analysis. But the sheriffs, the conceal and carry permit statute has a provision that if they deny you and it is later determined that they wrongly denied you, so say somebody, goes and wins at an ALJ or even takes it to the Court of Appeals and wins, that they are entitled to attorney's fees, which isn't damages, it's not the same thing, but it is, I think we could frame it to Shonda and others as sort of a step towards accountability that, if DHS is going to deny someone, they at least have some skin in the game if they litigate it and lose. And then it also solves another problem of making it much easier to access a private attorney to help you with that appeal.
What about, I guess I might take that one step even further, like the Data Practices Act, if that is violated, there is some monetary compensation.
Oh yeah, like up to $5,000 or something, right?
It might be 10, but where my head is going is, I mean, maybe it's not just attorney's fees, maybe it's also lost wages because we're keeping people out of work.
So it's
Rather than I mean, I guess
so
either
it's
a strict dollar amount or lost wages.
Well, I think one of the things that is hard for me to like, even like, I feel like we're putting the cart before the horse a little bit, right? Because how do you even prove, like, they don't track, like, there's no tracking, there's no monitoring in place, even with how, like when you talk about process, like, I'm not going to talk out loud about like who and all that stuff, but just the one I sent you guys the other day, right? I looked at the paperwork for that particular one, and had that person had some help with their set aside. There's no doubt in my mind that they would have gotten the set aside, right? And so looking at like which set asides that are rejected due to like bias or like deliberate discrimination, that there should be accountability, compared to ones that are like people didn't turn in their police reports, or people didn't like do a good job on the application, right? And so you guys are jumping to like penalizing the agency for what discrimination or whatever, but like there's not even a system in place to like monitor it, or, and so how do we get to that point?
I think I can address that, because I think so at least with the attorney's fees sort of portion of it, that would only come after an administrative law judge rules for the applicant against DHS. And then a step after that can be the attorney applying for attorney's fees. And anything that gets resolved before we get there, or anything that doesn't get there, right? Like a set aside that doesn't get appealed, wouldn't get to that. Or so somebody applies and they're denied and they do a set aside and they get it, fine, no problem, no attorney's fees. Someone does a set aside or gets disqualified, does a set aside, DHS says no to the set aside, and then they appeal. And in their appeal, they file a bunch more paperwork that convinces DHS that, oh, we should grant the set aside. And if DHS comes back and says, we don't need to go to the ALJ, we'll give you the set aside, again, no attorney's fees. It would really only be like the case that goes all the way to having a judge make a decision, and then only then, when the judge decides that DHS made an error, I don't think the judge is going to find, they don't need to make a factual finding that the error was based on discrimination, but they are going to make a factual finding that DHS abused its discretion and should not have just denied the set aside. It would only be in that situation then that the person would be in a position to recover attorney's fees or statutory compensation like the Data Practices Act.
Got it.
I think it would be pretty rare that it would actually happen. But I think it is a way to build some accountability that sidesteps qualified immunity. And I don't, I'd love to hear if Shonda thinks that, that would satisfy her. But other than doing that, the only other thing that I can really sort of think is that, like, hopefully when we get into the process part and we start making some recommendations about how the process should be easier, that we can frame that as approving the accountability by improving the process by which people access remedies.
Yep. Yep.
Well, and I just think, I mean, a couple thoughts on that one. I mean, one, obviously this would just be a recommendation and the legislature can, of course, do what they want with it. But I also think it sort of recognizes some of what I think has been talked about in the large group as well as various subcommittees, that these are individuals trying to do this who don't normally do this. And against, you know, quite frankly, the big brother type agency, I mean, you know, just the big agency, that big kind of bureaucratic body who's used to doing this. And at least just having that kind of extra accountability there, and maybe that will allow people to help get counsel, because you're not entitled to a public defender for something like this. And again, it's not that they're going to get it every time, but this is somebody's livelihood that we're talking about. I mean, this is their ability to earn a living and support a family. And so if they, you know, essentially abuse their discretion, then, and maybe it's just attorney's fees. Maybe that's all we leave it at for now, but I think it's already in other places in the statute that for other agency type decisions, it's not a stretch.
So there's precedent for it.
Right.
Other agencies. Yeah, I would love to have this conversation again when Tashanda's here.
Yeah, I think that makes
So,
sense.
I think
What I was hoping to do today when I asked to call the audible to raise this was at least to like lay a groundwork to have that conversation. So hopefully we can.
Well, and I like, you know, to me, you know, we already have the framework in other statutes. So there's a reason that that's there, that the legislature is determined. And so that, I think, it's not like we're just, you know, making something up that we think sounds fun and fancy. You know, it's there, and I think we can definitely see from the data that we do have that it is affecting, you know, a certain type of population more than others. So
yeah.
let's have some accountability.
So why don't we like put a pin in it, like, and I texted Tashanda the other day and got a text message back from somebody different at her organization that said that wasn't her number anymore. And so I think I'm going to check in with her and just see, let her know that we started talking about this today, and just make sure and if she can come to the next one. And then
I'm trying to decide if she's been in a while.
she was at the large group
Was she? Okay.
on Friday, but didn't have very good reception. And so like we talked about this a little bit, and she tried to like say something, but I don't know that.
Okay. Yeah.
Came across very clear. So
I think it's 12 o'clock. Let's pause here. I think we got a lot done today. I feel like we had a really good conversation. I think we've made progress. And then next time around, let's plan. Well, I guess Tashanda usually can't come right at 11. So maybe next time around, let's start with process. And then, you know, reserve maybe the last 15 minutes for this conversation. And get as far through process as we can next time. And so, Josh, obviously, I mean, it's depending on your schedule, I guess if for some reason you get kind of pulled into trials and are really crazy, just let us know and maybe we can try to pull a different audible next time.
Okay.
and and you guys can't meet next week?
I think Lucas has a trial.
Next week, well, no, next week I'm stacked with hearings in the morning. The 26th I'm available.
Okay. So you're busy next week.
Yeah, I have I actually have a maltreatment trial and an order for protection trial next week.
Okay. All right.
So that's just my
26th. Okay.
Yeah, 26th is safe.
Okay. Good deal.
All right.
Sweet.
Gina, you gonna call me?
I am. Yep.